Get a grip, then get a chip. Won't even trip. Though my cup was running over, I took only a sip. Stay hippin', then I'm hopping, I'm dropping. It won't be flopping, no shock. That whatever I'm selling, you will be copping. He was the strongest, though he was the one that cried. And he chose to kill his brother because he was from that side. And why? He chose this son because this one had pride. And instead of the narrow road, he chose the one that's wide. Sometimes the one that won was the one that tried. And the one who pulled the gun was the one that died. Looking good, a good look is the one that's fine. If I had to pick, fly would be the one that's mine. G-O-D, in the place to be. Attendee, Hard Knocks University. And since kindergarten, they've been hiding the knowledge. Homeboy is self-taught, never went to college. I'm brown skinned, I'm from Pelon. Rainy alarm, then I remain cool and calm. Reading Psalm, fire like napalm bomb.
Peace and blessings, baby. Peace and blessings, people. Peace and blessings, people. It's the constant creative force like Darth Vader, back on the track with the facts and all that. One path is the way that I'm taking, getting closer to God in a tight situation. We are in the information age on Do You Know Your Value page. As we proceed to give you what you need, long-awaited, highly anticipated part 5 of Creditors and their bonds. Beginning where we left off, here is the scenario when the man does not participate. An investigator from agency of a municipal corporation has filed information with a prosecuting attorney. Before things get this far, you should have completed your administrative procedure on the activity that is the subject matter of the court case. See the section on administrative process. The prosecuting attorney has decided to commence an action. The attorney creates a new trust to be the accused on a complaint or indictment, which is delivered into your hands. This time, you accept the presentment for value, return it, and authorize the use of your credit and bond the case. You give notice to the public on these private actions you have taken. Use third parties to testify to the agreement of the parties of the dishonor of the plaintiff, if necessary. You do not get involved in the issues of the case other than the agreement of the parties. You can bond the case. You do not have to be the trustee and represent the accused trust to take responsibility for the presumed violation of the state's statutes. You are one of the people. You are a creator with priority over fictions. You are the one who has the power to create a win-win situation for all parties. Creator. The prosecuting attorney is still the creator. Trust name. The name of the trust is still John Henry Doe. Trustor. The prosecuting attorney is still putting the charge into the trust as a corpus. Beneficiary. The beneficiary is still the state of. Trustee. Since you have not volunteered to be the trustee, the prosecuting attorney is still the responsible party. You are the one who accepted delivery of the complaint that was sent to the trust, over which you are presumed to be the trustee. If you can stay in honor while you take on the obligations of the trust by using your exemption and your credit as surety for the trust, you will be fine. You can argue with the attorneys and the judge and the witnesses and the clerk, showing how bad a trustee you are, or you can accept the state's request for revenue and authorize the use of your exemption credit. It is your choice. Surety. Suretyship on this case can be shared. Suretyship is a voluntary act. You can volunteer to be the surety using your exemption credit. Someone else can volunteer to dishonor someone or to dishonor the process, thereby becoming the surety. Free will is always a factor here. The big question is, who will be the surety? Since there seldom is a bond in the case until after the trial is over, you can present your bond to bond the case. Plaintiff. Whoever bonds the case is the plaintiff. Charges cannot be brought unless there's a bond. If the man supplies the bond, the man is the creditor. The tables can turn. You can do a counterclaim by removing the case into another court for judicial review of your administrative process and get an estoppel on their case. Defendant. The prosecuting attorney is the defendant unless there's a defense attorney who has put a notice of appearance into the case. If so, then the defense attorney is the defendant. As the creditor, you can authorize the prosecuting attorney or defense attorney, if he has filed a notice of appearance, to write the check to settle the account. The check is backed by your bond. Administrative process. Hypothetical situation. A few months ago, ABC agency sent the John H. Doe Trust an administrative presentment with a charge, energy of $5,000. It wants or needs $5,000. You are the source, the banker. If you don't give it to them, they will use your dishonor to support a claim of $5,000 worth of trust property. If you accept it for assessed value, $5,000 to return it, gave them an authorization to use your credit, you change your intentions for discharge of the charge, your acceptance is the return of the energy. They received your authorization, which may have been a bill of exchange, bond for discharge, or other instruments you choose to use. Now, ABC agency has hired an attorney to bring charges in the public against John H. Doe. A summons and complaint were delivered into your hands today. What do you do? One, realize this first. You're in the courtroom. You are in the courtroom on your case. John H. Doe may have removed ABC's case to a different court by filing an amendment complaint requesting judicial review of your administrative process. The purpose of this case is to get a public order that will overcome the claims being made in ABC agencies against John H. Doe. You have to introduce evidence into the judge's file to give him facts upon which he can base his decision. If you are asking for finding to facts, he must have some facts in the evidence file. You don't want the respondent to enter evidence and have his be the only evidence upon which the judge will base his decision. If you want conclusions of law, he must have some law in the evidence file. The only way facts and law get in the evidence file, the one the judge keeps in his possession, the clerk's file, you have to do. You have to introduce it in open court. County recorder, county assessor, notary public, or other public officer, to the bailiff or judge's clerk, who will then hand it to the judge. Have a copy for the notary also. You do not do this if there's a public defender. You have to introduce some law that supports your request into the record to give them something which to make conclusions of law. Putting this into the complaint as an exhibit and filing it with the bank, filing it with the clerk, and giving notice of it to the respondent does not get it to the judge's file. More on this part of the administrative process later in this section. You need evidence and facts and law. What do you want the judge to do? This is the time before you even do your administrative process to decide what you want and what evidence you will need to support what you want the judge in ABC's case or the judge in your removed case to review the administrative process and issue an order confirming the facts contained in the notary's certificate of dishonor or certificate of breach or certificate of non-response, whichever is appropriate for the situation. Even if you do not quote statutes, the notary certificate is recognized as prima facie evidence of the facts contained therein. Look at the commercial statutes for your state. The UCC source is 1202 or OCGA. This is for Georgia. OCGA subsection 11-1202. Since your administrative process will result in a certificate, this is the time to decide what you want from the one that sent the presentment to the straw man. Put the horse in front of the cart, or you may find that your certificate did not contain the exact wording you want to use in the certificate. It cannot be changed after the fact because the notary could be accused of making legal determinations or practicing law. Do not put your notaries in jeopardy. Step 2, prepare the certificate of non-response. This is the notary certificate. It is not yours. The notary will issue it to you. You will then be the holder of the certificate. It is like a bond in that it is evidence of the debt owed to you by the respondent who dishonored you by not responding or not complying with a duty. This certificate is 3 because it will be issued after the respondent has had 2 opportunities to honor you by complying with your request or performing a duty that is required of his office. This communication is not a response to your notice of acceptance and request or to a notary's notice of non-response. If it addresses some other issue, his response is an argument or testimony he is in dishonor. What do you want this certificate to say? If you use the bill of exchange, the name of the notary, name of presenter, name of acceptor, description of presentment, name of accused, state commercial statute regarding notary certificate, ARS 473-3505 and 47-1202 in Arizona, certificate statement, notice that presentment was accepted and returned with attachments with a request to the presenter at his company at its address by certified mail with return receipt and certificate of service. Notice of non-response with a second request to the presenter at his company at its address by certified mail with return receipt and certificate of service. Presenter refused requests. Presenter did not send notice of dishonor. Presenter did not cure his dishonor. Presenter agreed his dishonor. He dishonored the acceptor. The acceptor accepted the presentment. The acceptor returned the presentment. The acceptor exchanged his exemption for a discharge. The acceptor presented authorization to use his exemption for court charges. The acceptor sent processing instructions with the authorization. The acceptor sent a statement of account showing a zero balance. His refusal to send a confirmation or notice of dishonor did not negate settlement. He and his agency have no capacity to pursue collection. Further collection makes him and his agency liable for $5,000 to Strawman. Strawman can secure its $5,000 claim. Put the date, notary signature, notary seal, notary stamp, notary address, and administrative processing number. See sample 1. 3. Prepare your notice of acceptance. This is your acceptance notice. Cover letter to your acceptance of the presentment. You sign it, the notary mails it, and gives you a certificate of service with her stamp. And see sample 2, see sample 3, standard certificate of service. What do you want it to say? Certified mail number, name of notary, name of presenter, principal agent notice, the date, reference note, type of notice, and the facts. The acceptor has accepted the presentment. The acceptor is returning the presentment. The acceptor is exchanging his exemption for discharge. The acceptor is presenting authorization to use his exemption for court charges. The acceptor is sending processing instructions with the authorization. The acceptor is sending a statement of account showing a zero balance. The presenter's refusal to send the confirmation or notice of dishonor will not negate settlement. The presenter and his agency will have no capacity to pursue collection. Further collection makes the presenter and his agency liable for $5,000 to the strawman. Strawman can secure its $5,000 claim. Signature of acceptor, administrative processing number. 4. Prepare the notice of non-response for the notary. See sample 4. This is the notary's notice. This is your third-party public witness. What do you want it to say? Certified mail number, name of the notary, name of presenter, principal agent notice, date, reference note, and the facts. Notary sent notice and request by certified mail, return receipt requested, and certified and certificate of service. Presentment was dishonored. Notary is attaching copy of the first presentment to this notice of non-response. Notary is making a second request for the same thing. Performance or statement is expected in 10 days. Caveat: failure to cure breach will be agreement of parties to statements in first notice. Notary signature, notary seal, notary stamp, and administrative processing number. This completes the administrative process. You now have the certificate establishing A, that you accepted and returned and exchanged your exemption for discharge. B, that your acceptance was received and accepted by the respondent twice. C, that the respondent refused to respond or comply with your request. D, that there's an agreement of the parties. E, that the respondent has no commercial energy to pursue collection. F, that you have all the commercial energy regarding the subject account. G, that you are in honor. H, that the respondent is in dishonor. Court presentment, the state or city or county or an agency has just honored you with a presentment. It is a verified complaint or grand jury indictment or traffic ticket. Do you feel honored? No. Why not? Do you feel anger, fear? Do you feel fear, anger, confidence you can defend your position? Let's analyze this situation. State is used in this writing generically as a general term representing any corporate quasi-government organization and its agencies. You is using this writing to represent the reader, the living soul. Strawman is using this writing to represent an individual, U.S. citizen, but not a state as defined above. What is this presentment? What are its components? It has your name on it. Stop. It does not have your name on it. It has a strawman's name on it. The moving party has named the strawman as a violator of a statute and has asked you to take responsibility for the violation. The state, city, county, or IRS cannot file a claim against you. It is charging this strawman with a violation. Stop. It is establishing a value through an index associated with statute violations. This is ingenious. If you honor the presenter with an acceptance, a return, the index establishes the amount of credit you will provide to the state. If you dishonor the index, hold on. If you dishonor, the index establishes the amount of property the state will take to get the credit it needs. The presumption is that you are in partnership with that straw man. some cases, the index establishes how many months the state will hold your body for breach of fiduciary duty while it collects your credits. It suggests a time period for you to answer. Stop. Don't trust this one. It establishes a time period for the straw man to answer on the public side, usually 20 days. If you do not accept, if you don't accept in 72 hours from the private side, you will be in dishonor. The presentment is designed to help you into dishonor. You don't have to go into dishonor that way if you don't want to. It is the name, it as the name of the party bringing the claim. Someone has to approach you and ask you for your help. That person is taking a big chance. By signing his name, he can end up owing the amount the state is asking to provide. This is usually an attorney. He signs his name to it and becomes the attorney of record for plaintiff. State, through an attorney or other officer, has given you a court presentment, a request for your help. Options. You have options. Defend it, argue about it, conditionally accept it, ignore it, or accept it. You already know the right choice. You only have one good choice. Accept. If you defend, you are refusing to take responsibility for managing the affairs of your business, the United States. Whether you want to admit it or not, the U.S. is your creation. It continues in business because you authorized it. If you argue, you are in a controversy with your own business managers. If you conditionally accept, you are requiring the United States to prove it has a claim when it is in receivership and cannot have a valid claim against you without your permission. If you ignore the presentment, you are acting like an irresponsible creditor and will lose your status as creditor. Your only choice is to accept. That by itself is not enough, though. If you accept it and return it, you have not carried out the promise you made when you accepted it. It's like signing the requisition form but not instructing anyone who can write a check. You have accepted the presentments slash charges, but you have not given them what they need, your credit. It is like promising to pay the electric bill, but never getting around to it. If you do this, they will turn off the electricity. When you accept the presentment for value, when you accept the presentment for value, you have to follow through with some type of instrument. If you do not authorize the state to use your credit to settle the account after you have accepted, you are in dishonor. If you do not authorize the attorney to use your credit to settle the court account after you have accepted, you are in dishonor. The state and attorney will use your dishonors to charge their agents with authority to take the straw man's property, sheriff and or your body, bailiff. Either way, the state and the court will get the use of your credit. The United States and its states are in receivership, so they have no credit of their own. They need your credit and they will get it. The corporate counties and the cities are in this dysfunctional situation. They all need your credit. When they ask for it, give it to them. Follow through with your promise of acceptance and give them the use of your credit to cover the bond, the charges. Be the creditor you can be. And at this moment in time, we're going to pause and stop right here for part 5, creditors and their bonds. Very, very interesting document, if I might say so myself. And yeah, people, you gotta continue to do your own research and check out this information on your own time. Do your own research, check out the information on your own time. Get to a law dictionary. Also, you might want to get the Constitution. Get you a copy of House Joint Resolution 192. Read through that, and you're gonna come to find that all this information is the truth, the whole truth, and nothing but the truth. This is what the corporate government is doing. This is what the corporate government is doing, and the people are involved or co-conspirators. We can call them, or we can call the people, or we have been co-conspirators to the U.S. corporation and its scheme. Like I said, I'm going to end this right now. Peace and blessings. Don't you dare go testing.